Evelyn Hart had always believed that a quiet life well lived was its own reward. At 71 years old, she carried herself with the kind of dignified stillness that comes not from privilege, but from decades of choosing grace over grievance, patience over pride. She had silver hair she wore pinned back, hands roughened from years of real work, and eyes that still held a warmth most people half her age had already lost. She was not a woman who demanded attention. She never had been. And that, as it turned out, had been the single most expensive mistake of her life. The divorce papers arrived on a Thursday morning in April, slipped through the mail slot of the house she had shared with Gerald Hart for 41 years, as casually as if they were a grocery circular. No phone call, no conversation, no warning of any kind. Just a manila envelope with a return address from a law firm she had never heard of, and inside it, 70 pages of legal language dismantling 4 decades of shared existence into line items and asset columns. Evelyn sat at the kitchen table where she had eaten breakfast with Gerald every morning for 41 years and read every single page. Twice. Gerald was leaving her. Not for a reason he had ever bothered to explain to her face. Not after a conversation, not after counseling, not after any of the ordinary human courtesies you might extend to someone you had promised your life to. He was leaving her via attorney, via document, via the cold architecture of legal process. And according to the papers, he had been planning it for at least 18 months. She found out about the other woman 3 days later, when Dorothy, her neighbor and the closest thing she had to a best friend in the town of Carver Falls, Massachusetts, sat across from her at this same kitchen table, with the expression of someone delivering a terminal diagnosis. Her name was Linda Marsh. She was 44 years old. She worked in the accounting department of the pharmaceutical company, where Gerald had been a senior executive for the last 22 years. She and Gerald had apparently been together for 2 years, not 18 months, and according to Dorothy, who had heard it from the wife of Gerald's golf partner, Linda was already wearing a ring. Evelyn sat very still while Dorothy talked. She did not cry. She did not raise her voice. She felt something she could only describe later as a slow, complete draining, as if something essential that had been quietly sustaining her for 41 years had been running on a hidden tap, and someone had finally turned it off. She thought about the morning she had driven Gerald to his first day at Brennan Pharmaceuticals 22 years ago because his car was in the shop, and she had rearranged her entire week to make sure he got there. She thought about the year he had been passed over for a promotion he had expected, and how she had spent 6 months carefully rebuilding his confidence, cooking the meals he loved, keeping the house quiet when he needed to think, telling him every day that he was extraordinary. She thought about the 3 miscarriages before their son James was born, and how she had grieved each one mostly alone because Gerald found emotional difficulty uncomfortable and tended to retreat into work when things got hard. She thought about his mother, a difficult and demanding woman named Agnes, who had treated Evelyn with barely disguised contempt for 30 years, and how Evelyn had driven 2 hours each way every single week for the last 4 years of Agnes's life to sit with her, to manage her medications, to hold her hand when she was frightened, even when Agnes still called her the wrong name, sometimes on purpose. She thought about all of it, and she understood with the clarity that only genuine devastation provides that none of it had meant what she had believed it meant. She had been building a marriage inside a man who had stopped building it back somewhere along the way without ever telling her. The divorce proceedings lasted 14 months. They were, in the vocabulary of family law, contentious. Gerald's attorneys, a firm called Whitmore and Associates with offices in Boston, and a reputation Evelyn's own attorney described as aggressive and well-resourced, argued from the beginning that the bulk of Gerald's assets were the product of his professional career and therefore his separate property. They acknowledged the marital home, a colonial house in Carver Falls worth approximately $680,000, and a joint savings account containing $94,000 as shared assets. Everything else, they argued, belonged to Gerald alone. Everything else was considerable. Gerald Hart's compensation package at Brennan Pharmaceuticals included an annual salary of $340,000, stock options that had vested over 22 years into a portfolio worth approximately $4.1 million, a pension that would pay out $180,000 annually upon his retirement, which was planned, according to his attorneys, for the following year, and various other financial instruments totaling an additional $800,000. There was also a vacation property in Vermont, a ski chalet purchased in Gerald's name only 11 years ago, worth approximately $650,000. According to Gerald's attorneys, Evelyn was entitled to half the marital home, half the joint savings, and a spousal support payment of $3,200 per month for a period not to exceed 5 years. After 5 years, she would be entirely on her own. At 71 years old, with no career of her own, no recent work history, and no independent financial assets, she would be expected to support herself on whatever remained after the 5-year period expired. Evelyn's attorney, a woman named Patricia Osei, who was sharp and deeply committed and working with a budget a fraction of Whitmore and Associates, fought hard. She argued for a larger share of Gerald's professional assets on the grounds that Evelyn's domestic contributions had directly enabled Gerald's career. She presented evidence, years of evidence, showing that Evelyn had managed the household entirely, raised their son James with minimal involvement from Gerald, supported Gerald's professional entertaining, moved the family twice for his career advancement, and consistently subordinated her own potential earnings and professional development to the needs of his career. Gerald's attorneys countered with the argument that Evelyn had been generously supported throughout the marriage, had never been required to work, and had in fact chosen her domestic role freely. They submitted documentation showing that Evelyn had briefly attended nursing school in her late 20s before dropping out, framing her lack of career as a personal choice rather than a marital sacrifice. They characterized 41 years of devotion as a lifestyle choice for which she had already been adequately compensated by virtue of the comfortable existence Gerald's income had provided. The judge, a man named Howard Prescott, who had been on the family court bench for 19 years, ruled largely in Gerald's favor. Evelyn received the marital home, the joint savings, and spousal support of $2,800 per month for 5 years. She received nothing from the stock portfolio, nothing from the pension, nothing from the Vermont property. The ruling came down on a Tuesday afternoon in June, and Patricia Osei sat across from Evelyn in her small office and said quietly and with real sorrow that she was deeply sorry, that the ruling was unjust, and that the appeals process was possible but expensive and not guaranteed. Evelyn thanked her, shook her hand, and drove home. She sat in the driveway of the colonial house for a long time before going inside. The house was hers, technically. Half of it, anyway. The other half she would need to buy out using the joint savings, which meant the joint savings would be nearly gone. She would have the house, free of the mortgage Gerald's buyout share would cover, and $2,800 per month for 5 years. After that, Social Security, which would give her approximately $1,400 per month based on her work record from the brief years she had been employed before her marriage. She was 71 years old. She had perhaps 20 years of life remaining, statistically speaking. She would need to survive those 20 years on a house she couldn't sell without losing her only shelter, diminishing savings, temporary spousal support, and eventually a Social Security payment that would not cover her basic expenses in any reasonable scenario. Gerald, meanwhile, would retire to Vermont with Linda Marsh and his $4.1 million stock portfolio and his $180,000 annual pension, and his entire future intact. She did not cry that night either. She had moved, she realized, somewhere beyond the geography of ordinary grief into something colder and more structural. This was not sadness. This was reckoning. James called that evening. Her son was 43, a civil engineer living in Portland, Oregon, with his wife Carrie and their 2 daughters. He had followed the divorce proceedings with increasing fury on his mother's behalf, had offered money she had refused, and had called Gerald twice directly with results he described as deeply unsatisfying. "Mom," James said, his voice carrying the helpless frustration of someone watching an injustice unfold in slow motion. "This ruling is wrong. It's genuinely, legally wrong, and I want to appeal it." "I know it's wrong," Evelyn said, "but I need to think carefully about what comes next. Fighting in court costs money I don't have. There may be other ways." "What other ways?" James asked. "I don't know yet," she said honestly, "but I'm going to find out." She spent the following week doing what she had always done when facing problems that seemed insurmountable. She got organized. She pulled out every financial document from the marriage she had managed to copy during the proceedings, every tax return, every investment statement, every piece of correspondence she had kept over 4 decades of managing a household. She made lists. She thought carefully about what she knew, what she didn't know, and what she needed to learn. And then she made an appointment with a different kind of attorney. His name was Raymond Chu, and he specialized in estate and trust litigation with a secondary focus on forensic financial analysis in divorce cases. Patricia Osei had mentioned his name as someone who occasionally found things that standard divorce proceedings missed. He was 60 years old, methodical, and had the kind of careful eyes that suggested he found numbers more reliable than people. His office was in Worcester, not Boston, and his fees were structured for clients who couldn't afford Boston rates but had cases worth pursuing. Evelyn sat across from him with her organized folders and told him everything. She talked for 2 hours. Raymond Chu listened without interrupting, making notes in a small, precise handwriting that matched his general appearance of contained exactness. When she finished, he sat quietly for a moment. "Tell me about the Vermont property," he said. "The ski chalet. When exactly was it purchased?" 11 years ago, Evelyn said. "Gerald told me he was buying it as a business investment. He said one of his colleagues was interested in co-ownership for rental income. I signed something, I think, some kind of financial disclosure. But he handled all of it, and I didn't pay much attention. Do you remember the colleague's name? A man named Patterson. Warren Patterson. He was Gerald's golf partner for years. They had some kind of investment arrangement together," Gerald said. Raymond Chu wrote the name down carefully. "And during the marriage, how often did Gerald travel for work?" "Constantly," Evelyn said. "At least 2 weeks every month, sometimes more, for the entire 22 years at Brennan." Raymond Chu nodded slowly. "And the Vermont property. Did you ever visit it?" "Once," Evelyn said. "The summer before Gerald filed for divorce. He took me up there for a long weekend. He said he was thinking about selling it and wanted my opinion on the renovation work that had been done." She paused, something clicking into place. "He wanted my opinion on the renovation. I remember thinking that was unusual because he never asked my opinion about financial matters." Raymond Chu looked at her with the careful attention of someone who has just seen a key piece slot into a puzzle. "Mrs. Hart," he said, "I'd like to order some financial records. The Vermont property title history, Warren Patterson's connection to the purchase, and your husband's expense reports and compensation records at Brennan Pharmaceuticals for the last decade. It's going to take 6 to 8 weeks, but I think you may have come to me for exactly the right reason." "What are you looking for?" Evelyn asked. "I'm looking for where the money went," Raymond Chu said simply. "Because in my experience, when a man in Gerald Hart's position goes to the lengths he went to in order to minimize what his wife receives after 41 years of marriage, it's usually because the picture he presented to the court wasn't the complete picture." 6 weeks later, Raymond Chu called her back to his office in Worcester. He had spread a series of documents across his desk with the careful arrangement of someone presenting evidence that needed to be understood in order, not at random. He had brought in a colleague, a forensic accountant named Helen Marsh, no relation to Linda, who sat to his right with her own folder and the expression of someone who had found exactly what she expected to find, and was still somewhat astonished by the scale of it. "The Vermont property," Raymond Chu began, "was not purchased 11 years ago. It was purchased 17 years ago." Evelyn felt the room shift slightly. "But Gerald told me—" "Gerald told you what he needed you to believe," Raymond said gently. "The chalet was purchased in a shell company Gerald established in 2008, 7 years before he claimed to have bought it. Warren Patterson is not a co-owner. Warren Patterson is Gerald's attorney for this entity, not his golf partner. He has been for 17 years. Evelyn sat very still. "Why?" "Because 17 years ago," Raymond said, "Gerald began systematically moving assets out of his marital estate. He created a series of limited liability companies through which he routed a significant portion of his Brennan Pharmaceuticals compensation, particularly his stock grants and bonus income, over a period of 16 years. He did this gradually and carefully, in amounts and through structures designed specifically to avoid triggering the financial disclosures that a divorce proceeding would normally require." "How much?" Evelyn asked, though she already knew from the quality of silence in the room that the answer was going to change everything. Helen Marsh opened her folder. "Based on the records we've been able to access," she said, "the assets concealed through these structures amount to approximately $6.3 million. This includes the Vermont property, which was substantially renovated using these funds and is worth considerably more than the $650,000 it was assessed at during your divorce proceedings. Current market value is approximately $1.4 million. It also includes investment accounts held in the names of 2 shell companies, a property in Cape Cod Gerald, purchased 6 years ago, that was never disclosed during your proceedings, and approximately $900,000 in a foreign investment account opened in 2015. $6.3 million, Evelyn said. "That we've found so far," Helen said. There may be more. Evelyn thought about Judge Prescott's ruling, the fair and reasonable settlement of the marital assets, the $2,800 per month for 5 years, the implicit message that she had been generously provided for and had no legitimate claim to more. Gerald had hidden $6 million and then submitted to a divorce court claiming poverty relative to his actual wealth. He had submitted financial disclosures under oath that had omitted these assets entirely. He had watched a judge rule on an incomplete picture of his estate and had said nothing. Raymond Chu leaned forward. What Gerald did constitutes fraud upon the court, Evelyn. Financial fraud, perjury in his sworn disclosures, and potentially criminal fraud depending on how the structures were established. This doesn't just reopen your divorce settlement. This potentially exposes Gerald to criminal prosecution. What are my options? Evelyn asked. Raymond Chu laid out 3 paths with the precision of someone who had thought through all of them carefully before she arrived. The first was to file immediately to reopen the divorce settlement on grounds of fraud, presenting the financial evidence and seeking a court order to include the concealed assets in the marital estate. Given what they had found, he expected the court to respond forcefully. Gerald's attorneys would fight it, but they would be fighting against documented fraud, which was a significantly different battle than the one they had won previously. The second option was to present the evidence to the district attorney's office and request a criminal investigation. Fraud upon a court, perjury in financial disclosures, and potential securities violations in how the shell companies had been structured were all actionable offenses. Criminal prosecution would not directly give Evelyn money, but it would create leverage and would also, as Raymond Chu said with careful neutrality, have consequences for Gerald Hart's personal and professional situation. The third option was to do both simultaneously. I recommend the third option, Raymond Chu said, not because I enjoy complexity, but because in my experience, when someone has spent 17 years carefully building a structure to defraud their spouse, a single front challenge is easier to manage than a simultaneous civil and criminal exposure. Gerald's attorneys are very good, but they are not good at fighting on 2 fronts at once, especially when one of those fronts is criminal. Evelyn looked at him. She thought about Gerald's face at the divorce settlement meeting, the brief satisfied expression he had allowed himself when the judge read the ruling, a flash of victory so quickly concealed she had wondered afterward if she had imagined it. She had not imagined it. She thought about the 41 years she had given to a man who had spent 17 of them carefully building the mechanism of her abandonment. Do it, she said. Both. All of it. The motion to reopen the divorce settlement was filed in Worcester Superior Court on a Monday morning in September. Raymond Chu had timed the filing to coincide with a meeting he had arranged the previous Thursday with an investigator from the State Attorney General's Financial Crimes Division, a woman named Agent Delgado, to whom he had presented a summary of the concealed asset evidence. Agent Delgado had been, in Raymond's characterization, extremely interested. Gerald's attorneys received notice of the motion on Monday morning and notice of the criminal investigation inquiry by Wednesday afternoon. Raymond Chu had it from multiple sources that Thomas Whitmore of Whitmore and Associates made 3 very loud phone calls to Gerald Hart on Wednesday afternoon after receiving Agent Delgado's inquiry letter. Gerald's response, communicated through his attorneys the following week, was to deny everything. He denied knowledge of the shell companies, claiming that Warren Patterson had managed these entities on his behalf as investment vehicles and that he had not understood them to be required disclosures under Massachusetts marital law. He denied that the Vermont property's true value had been intentionally misrepresented. He denied that the Cape Cod property existed as a personal asset, claiming it was owned entirely by one of the corporate entities and therefore not a marital holding. He denied the foreign account entirely, which was bold given that Raymond's forensic accountant had its account number. The denial strategy lasted approximately 3 weeks. It collapsed when Agent Delgado's office subpoenaed records directly from Brennan Pharmaceuticals, which had its own legal exposure to consider, given that some of Gerald's stock grant routing appeared to have involved the company's compensation infrastructure. Brennan Pharmaceuticals cooperated immediately and completely. They had their own attorneys and their own interests, and Gerald Hart was a retired executive, not a protected asset. The subpoenaed records showed not only the complete picture of Gerald's concealed assets, but also a series of internal emails, carelessly preserved on Brennan's servers, in which Gerald and Warren Patterson discussed the divorce strategy with a frankness that Raymond Chu described, with visible satisfaction, as extraordinarily helpful to their case. In one email from 3 years before Gerald filed for divorce, Gerald had written to Patterson, Evelyn will get the house and a few years of support. She has no idea what I actually have, and no ability to find it. By the time the support runs out, she'll be 76 and completely dependent on James. It'll be clean. Evelyn read that email on a Thursday afternoon in Raymond Chu's office. She read it twice, the way she had read the divorce papers at her kitchen table. Then she set it down. He planned this for at least 3 years before he filed, she said. At minimum, Raymond confirmed. She thought about all the things she'd been doing during those 3 years while Gerald was composing that email. She had been managing his mother Agnes's final decline, driving 2 hours each way to sit with a woman who didn't always remember her name. She had been organizing the 41st anniversary party that Gerald had suggested, and she had spent 4 months planning, inviting 80 of their friends and colleagues, cooking for 2 days beforehand, making sure everything was perfect for the celebration of a marriage he was already planning to dismantle. She had been, as she had always been, completely and trustingly present in a life that her partner was treating as a disposal problem. The settlement negotiations that followed were, in Raymond Chu's professional opinion, among the swiftest he had witnessed in 30 years of practice. Gerald's attorneys, confronted with documented fraud, a parallel criminal investigation, the Brennan emails, and a forensic accounting trail that grew more comprehensive every week, abandoned the denial strategy entirely and moved directly to negotiation. Gerald wanted the criminal matter to go away. That was, Raymond said, his primary motivation now. The civil settlement was secondary to keeping the Attorney General's office from pursuing prosecution. Evelyn understood this, and she used it. The settlement she ultimately received included her full half of all concealed assets, including the Shell Company holdings, the Vermont property at its true value, the Cape Cod property, and the foreign account. It included a revised spousal support arrangement of $8,500 per month for life, rather than the original $2,800 for 5 years. It included Gerald's legal agreement to cover all her legal fees from both the original proceedings and the reopening. It included a substantial cash payment described in the documents as compensatory damages for the fraudulent concealment, an amount that brought Evelyn's total recovery to just over $4.2 million in cash and property combined. In exchange, Evelyn agreed not to pursue the criminal matter further, which was to say that she agreed not to actively encourage the Attorney General's office to proceed, though Raymond was careful to explain that she could not prevent them from doing so on their own initiative, and that Agent Delgado had made no promises. Agent Delgado did, in fact, pursue the matter independently. Gerald Hart was charged with 1 count of fraud upon the court, 2 counts of perjury and sworn financial disclosures, and 1 count of financial concealment. He was not imprisoned. He received 3 years of probation, a substantial fine, and a public record of criminal conviction that appeared in every Google search of his name for the foreseeable future. His retirement at Brennan Pharmaceuticals, which had been planned with considerable ceremony, instead concluded with a quiet administrative departure that the company described in its internal communications as a separation by mutual agreement. Linda Marsh, who had apparently believed she was marrying a wealthy retired pharmaceutical executive, discovered that she was marrying a man on criminal probation with significantly diminished assets and a court-monitored financial situation. She returned the ring. Gerald's attorney communicated this development to Raymond Chu in what Raymond described as an unexpectedly informal phone call, the tone of which suggested even Whitmore and Associates had complicated feelings about the situation. Evelyn learned about Linda's departure on a Tuesday morning and felt something she had not expected to feel. Not satisfaction, not vindication, though both of those were present in smaller measures. What she felt, most substantially, was a complete release of attention. Gerald Hart and his choices and his consequences were simply no longer a weight she was carrying. She set them down as cleanly as you set down a bag you have been carrying for much too long, and she discovered that her hands were free. She was 72 years old by the time the settlement was finalized. James flew in from Portland and sat at the kitchen table where the divorce papers had arrived, and they had dinner together. The 2 of them, the way they had on countless evenings during his childhood when Gerald had been traveling, which was most evenings. James cried briefly at one point, not from sadness, but from relief and some complicated amalgam of emotions that had been building in him for 2 years. Evelyn held his hand across the table the way she had when he was small and frightened of things she could protect him from. "You're going to be all right, Mom," James said. "I know," Evelyn said. "I've known that for a while now, actually. I just needed to make sure the situation was also all right." James laughed at that, a real laugh, and Evelyn found herself laughing too, for the first time in longer than she could precisely remember. She began thinking seriously about what came next. The house in Carver Falls was fully paid, settled into her sole ownership as part of the final resolution. It was large for one person, a 4-bedroom colonial designed for a family, and she had rattled around in it for 2 years in a way that had sometimes felt less like living and more like haunting a structure that had outlasted its purpose. She had thought about selling it and moving somewhere smaller, somewhere new, somewhere that didn't hold 41 years of a particular kind of memory in every room. But she had also thought about the women she had met in the past 2 years who were living versions of the fear she had felt when she first read those divorce papers. Women her age and younger who had spent their lives inside marriages that ended badly, who had emerged from those endings with nothing and no knowledge of how to find anything. Women who had been told, explicitly or implicitly, that their contributions were worth less than they were, that their age made them liabilities rather than resources, that the years behind them were closed chapters rather than foundations for what was still possible. She had found, in the past 2 years of legal fighting and financial learning and very gradual rebuilding, that she knew things. She had learned things she had never expected to need to know. She understood now how asset concealment worked in divorce proceedings, what forensic financial analysis could find, what questions to ask and when to ask them, what rights a spouse retained even after a court had ruled against her. She understood the specific and particular experience of being a woman in her 7th decade who had been told by a legal system that she was essentially a concluded matter. And she had found, somewhat to her surprise, a capacity for strategic thinking she had not known she possessed. The Evelyn who had managed Gerald's social calendar and cared for his mother and organized his 40th anniversary party had been genuinely competent, but her competence had been entirely in service of his life. The Evelyn who had sat across from Raymond Chu and said, "Do it," both, all of it, had accessed something different, something that had always been there and had never been given its proper circumstances. She converted the 2 largest unused rooms in the house into a small office suite and a resource library. She connected with Patricia Osei, her original attorney, and with Raymond Chu, and with a social worker named Miriam Torres, who ran a domestic transitions program through the Worcester County Social Services Office. She connected with a financial literacy educator at the local community college, and with a retired judge who had found the widespread misunderstanding of marital asset law genuinely troubling and was willing to give occasional informational presentations. She called the organization she was establishing the Heart Resource Center, which was a useful double meaning she had noticed quietly and chosen deliberately. Heart as in her own name, as in the woman who had gone through this and come out the other side with knowledge worth sharing. Heart as in the thing that keeps functioning even after it has been broken, the thing that, given adequate circumstances, keeps generating warmth. Dorothy, her neighbor, became the first volunteer. She recruited others. The community college offered a meeting room on Tuesday and Thursday evenings. Within 4 months, Evelyn was running 2 weekly sessions providing free information and referral services to women navigating divorce, asset disputes, and financial rebuilding in later life. The waiting list for one-on-one consultations with the volunteer attorneys she had assembled, including Patricia Osei and 2 others she had found through professional networks, was consistently 3 weeks long. James came to visit 6 months after the center opened and sat in the back of a Tuesday evening session, watching his mother stand at the front of a community college classroom and walk 16 women through the basics of marital asset disclosure requirements under Massachusetts law. He was quiet on the drive back to the house afterward, and Evelyn let the quiet sit for a while before asking what he was thinking. "I was thinking," James said carefully, "that I spent 2 years being furious on your behalf, and somewhere in the last hour I realized that what happened to you was terrible and unjust, and that you have turned it into something that will prevent the same thing from happening to other people." He was quiet again. "I was also thinking that I don't know very many people who could do that. I'm not sure I could." "You would," Evelyn said, "if you had to." People do, she thought, but didn't say, that she had not chosen to do this out of nobility. She had chosen it partly because having something to build was the only way she had found to make the destruction behind her feel like preparation rather than simply loss. She had rebuilt because the alternative was to be rebuilt by circumstances, and she had seen enough of what circumstances did when left to their own inclinations. The Heart Resource Center received a small grant from the County Health and Human Services Department in its 2nd year, which allowed it to hire a part-time coordinator and expand to 4 evenings per week. Miriam Torres joined the board. Raymond Chu offered pro bono hours on a regular monthly basis. Patricia Osei did the same. A local news station ran a story on it in the spring, a short segment on the evening news about community resources for women facing late-life financial disruption, and the inquiry volume tripled in the following week. Evelyn hired a second coordinator. She converted the garage into an additional meeting space. She began a monthly workshop series on financial self-sufficiency for women over 60 that drew participants not just from Carver Falls, but from 3 surrounding counties. She was 73 when the center opened its doors to its 100th client. She was 74 when a woman named Barbara arrived, 68 years old, and 2 weeks out of a 38-year marriage that had ended with a settlement she suspected had been built on incomplete financial disclosures. And Evelyn sat across from her at a table in the resource library and looked at her face and recognized it completely. "I know exactly what this feels like," Evelyn said. "And I want you to know that what it feels like right now is not what it will feel like in 2 years. You have more options than you know. We are going to find every single one of them." Barbara looked at her with the specific expression of someone who wants desperately to believe something and is not yet able to. Evelyn recognized that expression too. She had worn it herself, sitting in Patricia Osei's small office after the original ruling, learning for the first time that unjust outcomes were not necessarily final outcomes. "You found your way out?" Barbara asked. "I found my way through," Evelyn said. "Out suggests you end up somewhere separate from where you've been. Through means you carry it with you, but it doesn't carry you. That's what we're going to work toward." She thought about Gerald sometimes, less than she had expected, and in a different register than she had anticipated, not with the hot specificity of anger, which had burned itself largely out somewhere in the 3rd month of the second legal proceeding. More with a kind of historical interest, the way you might think about a significant event that happened to someone you once knew well. He was living in a rented apartment in Framingham, according to James, who had heard from a mutual acquaintance. The Vermont chalet had been sold as part of the settlement. The Cape Cod property had been sold. Linda Marsh was living her own separate life. Gerald was navigating retirement on a fraction of what he had planned, and on a public record that followed him through every professional and social introduction. Evelyn did not pursue this information actively. It arrived occasionally the way information about people from your past tends to arrive, through the peripheral channels of shared social geography, and she received it with the same mild historical interest with which she thought about him. She had no ongoing capacity for either satisfaction at his diminishment or sympathy for it. He was simply no longer a central figure in the story she was living. The story she was living was about the Hart Resource Center, and about the women who came through it, and about what happened to people when they discovered that the situation they had believed was hopeless had actual, specific, legal, financial, and personal remedies available to them if someone would simply sit down and explain what those remedies were. It was about Dorothy, who had shown up with bread and eggs and milk when Evelyn first moved back into the empty house alone, and who now served on the center's board and ran the Thursday evening newcomer orientation with a combination of warmth and practical directness that made first-time visitors immediately feel that they had arrived somewhere useful. It was about James, who had offered money she had refused, and then learned, in watching his mother build something from nothing, a different lesson than the one money would have taught either of them. It was about Raymond Chu, who had found $6.3 million in places Gerald had been certain no one would ever look, and who now spent 4 hours every 3rd Tuesday sitting with women in financial situations that required someone who found numbers more reliable than people and used that reliability in their service. It was about the moment, which arrived for almost every woman who came through the center's doors, when they shifted from the posture of someone who has had something done to them into the posture of someone who is doing something about it. Evelyn had watched this shift happen dozens of times now, and it was different every time and recognizable every time, and it never stopped moving her. She was 75 years old on the morning she sat on her back porch drinking coffee and looking at the garden she had replanted entirely from scratch 2 summers ago, because the original garden had been Gerald's preferences as much as hers, and she had wanted to start from what she actually loved. The garden was in full June bloom, all deep purples and bright yellows, and the kind of structural disorder that looks accidental and is in fact carefully considered. She had learned to garden from her mother and had not gardened seriously for 40 years because Gerald found gardens mildly allergenic, and she had accommodated this the way she had accommodated so many things, quietly and without resentment and without entirely noticing the accumulation. She was noticing it now. The garden, the house arranged around her own habits and her own comfort rather than anyone else's. The Tuesday and Thursday evenings spent in rooms full of women learning that their circumstances were navigable. The coffee she drank at exactly the pace she chose in the quiet of a morning that belonged entirely to her. She was noticing all of it with a gratitude that was entirely undramatic and completely genuine. 41 years of marriage, she thought. 14 months of divorce proceedings. 2 years of building something new. She was doing arithmetic not of grievance but of plain time, trying to understand something about how the same quantity of years could mean such different things depending on what was being done with them. She thought about something Patricia Osi had said to her early in the original proceedings, when Evelyn had sat across from her and tried to understand how a court could look at 41 years of domestic contribution and find it worth so little. Patricia had been quiet for a moment and then said, carefully and with the precision of someone stating something she believed was true but knew was hard to hear, "The legal system was not designed to value what you did. It was designed by people who had someone at home doing what you did, so they never had to think about its value. That doesn't make what you did worth less. It makes the system incomplete." Evelyn had thought about those words many times in the years since. She thought about them now, sitting in her own garden, in her own morning, and found that she agreed, and also found that incomplete systems were not immovable systems. They were systems that required people who understood their incompleteness to show up and do the work of filling the gaps. That was what the Heart Resource Center was. That was what the Tuesday and Thursday evenings were. That was what she was. She had a meeting that afternoon with a woman from the State Attorney General's office who was developing new disclosure requirement guidelines for divorce proceedings in Massachusetts. Guidelines designed specifically to address the kind of concealment Gerald had employed and that, according to Raymond Chu's forensic work, was far more common than the legal system had previously acknowledged or addressed. They wanted Evelyn's input based on her case and her 2 years of working with women in similar situations. They wanted to understand, practically and specifically, what a more complete system would need to require. She had spent the previous evening preparing notes, 3 pages of precise, organized observations about where current requirements failed and what a comprehensive revision would need to include, written in the careful handwriting of a woman who had managed complex household logistics for 4 decades and had discovered, in her 7th decade, that the skill set was transferable to any situation requiring attention to detail and long horizon thinking. She finished her coffee and went inside to get her notes and her keys. She had somewhere to be. She was, as it turned out, and as she was still somewhat surprised to discover, always somewhere to be now. Evelyn Hart was 75 years old. She had spent 41 years being essential in ways that went unrecognized and unrewarded. She had been discarded with legal precision by a man who had spent 17 years building the machinery of her abandonment. She had been handed a settlement designed to leave her dependent and diminished, and had instead found, in the documentation of that injustice, the foundation of something that outlasted the injustice entirely. She was not finished. She was not even close to finished. And the women who walked through the doors of the Heart Resource Center every Tuesday and Thursday evening, carrying the specific weight of lives that had been organized around other people's needs and were now, at last, available to be organized around their own, understood this in their bones the moment they sat across from her and saw in her face not the soft resignation of someone who had accepted less than they deserved, but the steady, grounded, entirely undramatic confidence of someone who had gone through the worst of it and come out the other side knowing exactly who she was and precisely what she was worth, which was, as it turned out, considerably more than anyone had thought to put in the papers.